since now there is an addition of councils, my lord, on this side, I'll also have to, my lord, compress the submission so that your lordships may at least, my lord, attempt to conclude on this today. Finalize that late night, my lord.
Why don't you mail it to us? Mail it to the court master. First, you need to mail it to the court master. Immediately mail it to us.
I'll immediately do.
And drop it in.
Lord, I'll just, Lord, give 6 propositions. But I am appearing for the Union of India. I am indeed grateful that your lordships allowed me, my lord, though I am not a party. But your lordships have 2 extreme positions. One saying that it applies completely, and one saying that it can never apply. And there is an exclusionary exclusionary statutory mechanism. That's one side of the argument. Lord, my argument will be nuanced arguments because we want this act to become effective and functional. And it does not become effective and functional if disputes are fragmented.
Yes.
Lord, 5 points, my lord. I'll just very briefly take your lordships to the history as to how, my lord, this act came to be enacted. Because, my lord, some arguments are bound to be made. They were made on this side, will be made on that side. That some jurisdictions have accepted, some jurisdictions have not accepted this doctrine. That will be the first limb. Second limb would be that in my respectful submission, the doctrine of group of companies is intrinsically inbuilt in the statute itself. And I'll attempt to show that. There is no exclusion in the statute. There is no exclusion of this doctrine. It is there. Third,
Sorry, what was the first point?
first was a general history, my lord, because that would give your lordships, my lord, assistance as to how to interpret, my lord, our statutory mechanism in arbitration.
All right.
Second would be, my lord, that doctrine, group of companies doctrine is intrinsically inbuilt in the statute itself.
Yes.
Third, presuming that the act excludes that doctrine or act does not at least include the doctrine, but my submission is going to be that doctrinal approach your lordships have always evolved. Everything is not to be found in the letter of law. Your lordships infuse blood and soul by developing doctrines for interpretation of the statute as it stands. And that's how, my lord, the law evolves. Fourth, my lord, how other jurisdictions have treated doctrine of group of companies and what are the parameters, what are the contours they have relied upon. But ultimately, my lord, ultimately the bottom line of all these jurisdictions would be that your lordships may perhaps be able to lay down illustrative cases if your lordships accept the doctrine, but eventually it will be a case-specific determination if the doctrine is to be applied in our act. And last, Lord, what would be the, if your lordship is subject to what your lordship ultimately decides, whether the doctrine applies in our Indian scheme of statute or does not apply, but if it applies, what would be the contours of the court's jurisdiction under Section 8 and the jurisdiction of my lord the Chief Justice or his lordship's designate under Section 11, subsection 6? To what extent, my lord, the examination would be required at that stage?
Yes.
Yes, my lord, since my lord, there are other, my learned friends are also, my lord, I'll compress it, and what may not be directly relevant, my lord, I'll point out briefly. Lord, first of all, so far as history is concerned, your lordships are aware, whatever is relevant for the present dispute. Lord, this alternative dispute mechanism concept started in 1923 with Vienna Convention. Sorry, Geneva Convention, I'm sorry, Geneva Convention, 23 and 27. But it was too broad-based mechanism, and in fact, it was not a mechanism at all, which led to eventually New York Convention. The New York Convention essentially dealt with enforcement of foreign awards. There was no mechanism provided as to how to arbitrate. What are the powers of the arbitrator? What are the rights and responsibilities of the parties? What will be the substantive law? What will be the procedural law? What will be the curial law, etc. Nothing was, my lord, in New York Convention earmarked, but 172 states, my lord, in the context of international law, 172 countries adopted the New York Convention. Lord, that a global need was found that there has to be a model infrastructure which can be adopted by the states and which can become their respective domestic statutory law. And there comes, Lord, unicitral model law. United Nations, my lord, prepared a model law in 1985, amended in 2006. So there are 82 countries which have adopted the model laws, including India. Lord, why this is necessary? Broadly speaking, globally, there are two bifurcations or two divisions. One, who have their domestic law in tune with or in conformity with unicitral model law. They are broadly referred to as model law countries. And others, they go by their own domestic law. They have their own laws, may or may not be in conformity with unicitral law. Even if it is in conformity, it's not because they have adopted or assented to or become a signatory. They have picked up some issues. So there are two broad classifications of the countries. Now, my lord, I come to the main issue, Lord, my respectful submission and the first submission, that this doctrine is inbuilt in the statute itself. And there is no exclusion, my lord, as argued. Lord, if I am right in reading the provision the way I read, then, my lord, we need not find anywhere else any provision for exclusion or inclusion. It is included, impliedly, intrinsically. Lord, kindly, therefore, on this point, come to page 2. I've quoted, my lord, some of the provisions to, my lord, make myself, my lord, more clear. As pointed out above, the Act uses certain terms, expressions, and phrases very broadly so as to not reflect the scope of alternative dispute redressal mechanism in minimum category of cases only. By way of an example, the term international commercial arbitration as defined under section 21F broadly takes within its wide sweep all arbitration relating to, please mark this, my lord, something would turn on this, my lord, therefore I have underlined it, dispute arising out of legal relationship, whether contractual or not. Lord, very widely worded term, any kind of relationship, if it gives rise to or give birth to a legal relationship, and irrespective whether it is contractually incorporated or not, it would become a subject matter of international commercial arbitration. So
Yes.
now, Lord, why I pointed out the unicitral model law which we have adopted. Unicitral model law essentially dealt with and deals with international commercial arbitration. The respectful submission is the commercial element of any dispute or a business sense element of any dispute is implicit, it's intrinsic in our act also. Though our act is not restricted to commercial disputes, there can be other disputes as well. Now, please come to para 6. Coming to domestic arbitration, also it is clear that the group of company doctrine has remained inbuilt in the scheme of the Act before and after Law Commission's report number 246 and the amendment made in the year 2015 based thereon. Firstly, the term arbitration agreement is consciously not defined either under Section 2 or elsewhere so as to include only an agreement in conventional sense of the term as used in Indian Contract Act or elsewhere. The legislature has very consciously avoided a restrictive definition which gives a conventional meaning to the term agreement, that is, a document executed by the parties at the foot of which the parties would put their signatures. Lord, nothing prevented the legislature from saying that arbitration agreement would be between parties who will be the signatories to the arbitration agreement. The definition says this, and in my respectful submission, it reflects the legislative intent. Arbitration agreement means an agreement referred to in Section 7. Am I with your lordship?
Yes.
At this stage, for the present purpose, the definition of the term parties as used in Section 2H needs to be examined. Section 2H reads as under, party means a party to an arbitration agreement. So agreement is not defined. Agreement means whatever takes color of an agreement under Section 7. And the party is also not defined except to say that whoever falls within 7 will be a party for the purpose of this act. On true, meaningful, and purposive interpretation of the act, that is speedy, less time consuming, comprehensive, unfragmented, and effective resolution of all disputes, it becomes clear that Section 7 itself statutorily recognized group of companies doctrine. The key word in my respectful submission is unfragmented dispute resolution. I have a dispute with A, but B is also a part of that dispute. So don't fragment it merely by giving a restricting meaning that I will have relationship with A and therefore arbitration between me and A, but for B I have to file a suit. That's not the intent. Now please see, my lord, the definition of the arbitration agreement. Lord, I have quoted Section 7. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. I would respectfully read, my lord, subsection 1 like this. Arbitration agreement is an agreement made by the parties when you can show that there is a defined relationship. It need not have contractual foundation. Then it would be an arbitration agreement. Not necessarily between A and B, not necessarily having a contract between A and B, reduced as a contract between A and B, not in the conventional sense of the term agreement as used in the Contract Act. Now, your lordships can do. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Well, we are not concerned for this matter. 3, an arbitration agreement shall be in writing. Mr. Sibal laid emphasis on this, my lord, and read 4A with that. It will have to be in writing. And it is so. I can't dispute that. Now, please see 4A. An arbitration agreement is in writing if it is contained in a document signed by the parties. This is the first kind of arbitration agreement. This is not the only kind of arbitration agreement. If it is signed by the parties, then it is an arbitration agreement. But B, if the legislature would have stopped at 4A, possibly the restrictive meaning was possible. That it has to be signed by the parties, it should be in writing, and that document only creates a legal relationship, defined legal relationship. But please come to B. Now, there is no, my lord, arbitration agreement as contemplated under 7(4)(a). An exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. Please, my lord, mark, which provide a record of the agreement. Lord, in my respect,
Record of the agreement would mean from which you can deduce the essential terms of the.
I'm obliged, my lords. I could not have put it that succinctly. My respectful submission is the record of the agreement means any act of agreeing to certain things, not agreement in the conventional sense. So, my lord, if there is an exchange of correspondence between A, B, and C, the contract may be between A and B, but the correspondence reflects that C also understood the contract to mean that he will also perform some part of the contract. And I'll show, my lord, how such instances have happened. I'll show very, very briefly. But suppose back-to-back contracts, that during the correspondence between us, I say that I'll supply to Mr. Khambhata and Mr. Khambhata will in turn supply to Mr. Nakul Dev. The arbitration may be between the two, the agreement between the two of them. But during the correspondence, it comes out that I have also agreed to certain things to be done in a certain way. Then, not merely because I am not a party to the arbitration agreement or arbitration clause, if it is a separate agreement, but I cannot say that now I can't be joined in yours. Otherwise, my lord, the legislature would have used a very simple language. Arbitration agreement means an agreement between the parties to the dispute. And the parties would mean signatories to the agreement.
Yes.
So, my lord, my respectful submission is the term parties are not used in the same sense as we understand signatories. you can be a party without being a signatory to an arbitration agreement or a substantive agreement which contains an arbitration clause. Now, my lord, kindly see page 4, para, at the foot, para 11. The concept of business prudence ingrained in section 2(1)(f) for international commercial arbitration is again inbuilt and ingrained in section 7. Section 7 neither restricts the term agreement to be one conventional document nor restricts it either document-wise or party-wise. It uses a broad expression defined relationship, whether contractual or not. This is clearly suggestive of the legislative intent that any kind of legal relationship, even if it is not contractual, that is, there is no contract between the entity, my lord. I am not using the word party or signatory. Between the entity whose actions or participation results in a defined relationship can form the subject matter of an arbitration agreement. That's why this wide definition consciously chosen. 12, my lord, I have already pointed out. 13. Section 7(4) mandates an arbitration agreement to be in writing. The conventional agreement which comes to one's mind, that is a written document describing inter se rights and liabilities between the signatories to the document, bearing the signature of such contracting parties in such agreement, is placed in section 7(4)(a) as a separate and distinct category. Now, next, the said agreement contemplated under 7(4)(a) is, however, not restrictive, but will be guided by 7(1). So, my lord, there can be, my lord, kindly pause here for a minute. There can be an agreement which is under 4(a), document signed by the parties. I'm sorry, 7(4)(a), which is a document signed by the parties, but it will have to be examined under 7(1), because it can be an agreement where it clearly comes out a defined relationship which may not be contractual under this agreement. Lord, I hope, my lord, I am able to make myself clear. My lord, continuously, my lord, I am saying, my lord, in their contract, Mr. Khambata and Mr. Devan's contract, they continuously refer that the goods will be supplied by Mr. Mehta. I am not, my lord, a document signed by the parties. I am not a signatory to that document. But from the document, it emerges that there is a defined legal relationship emerging from that document. Like, for example, there are certain obligations incorporated by reference. They can say, Mr. Khambata can say that I'll supply goods to Mr. Devan, but we have a separate agreement dated so-and-so, registered at so-and-so with Mr. Mehta, and he has agreed thereby that he would supply the similar goods to me, which I will supply to him. So
I may not have bargained for a contractual relationship between you and Mr. Devan, in your example.
Yes.
Unless there is a tacit acceptance by you of the obligation which Mr. Khambata has assumed to supply goods to Mr. Devan, you would not be liable.
No,
Merely because, say, suppose, for instance, you are the foreign collaborator of Mr. Khambata's client. All right, that you are the person who has prepared the software, or you have prepared the service agreement, the license agreement. You are the real originator of it all. Unless there is something to indicate that, look, you have assumed the obligation, or that you stand behind the obligation which Mr. Khambata has assumed to.
I vowed. Yeah. That is why I emphasize it must emerge a defined legal relationship with respect to the dispute. I'll just give an example, simpler example. Look, Tata Steel is a Tata group of companies.
Yes.
Tata Motors is a Tata group of companies. Suppose Tata Motors enters into an agreement with me for buying certain products, tires, machinery, etc., etc., and there is a dispute between the two of us. I can't involve Tata Steel saying that it's a group of companies. If he is unable to pay, you pay. But if there is a defined legal relationship with third person, and that is how, my lord, the courts have construed. Defined legal relationships are presumed under various doctrines which your lordships have evolved. in other jurisdictions also. Back-to-back contract is one such thing. It would be a fact-specific determination.
Right.
There would not be any straight jacket answer. But the point I am respectfully urging for your Lordship's consideration is there is no exclusion. In fact, Section 7 incorporates group of company doctrines by not restricting it to mere parties to the agreement, except in 4.1a, 7.4a, but it restricts even correspondence. There can be a correspondence that, all right, we supply, they supply, etc., etc. Lord, now kindly come to page 10. It is thus clear that even if there is a contractual document in existence between party A and B, as contemplated under section 7.4, I'm sorry, page 6, page 6. It is thus clear that even if there is a contractual document in existence between party A and party B, as contemplated under section 7.4a, if both of them have a defined legal relationship with entity C or D, qua the dispute, not my lord, some other relationship. I am now, my lord, restricting to give a purposive meaning, my lord, and to ensure that it doesn't become an unruly horse where anybody and everybody is included. Qua the dispute, an arbitration would take place amongst A, B, C, and D, irrespective of as to whether A, B, C, or D are contractually connected with each other, or irrespective of whether C or D are signatories to the document contemplated under section 7.4a. Well, this is the crux. So parties are not to be read as synonymous of signatories, and the existence of a defined relationship, legal relationship, can be inferred from the correspondence also. Lord, kindly come to, ignore 14, come to 15. Lord. Section 7.4b, however, makes above referred legislative intent more clear. It specifically does away with mandatory existence of a conventional document only to be regarded as an arbitration agreement. Under the scheme of 2H and 7, even exchange of letters, telex, so and so, is an arbitration agreement if it provides a record of agreement based upon a legal relationship. Now, my lord, next is relevant, as my lord very succinctly, my lord, fell from my lord the Chief Justice of India, the subpara.
Yes.
Subpara. In other words, the term agreement, except as used in section 7.4a, that is document signed by the parties, is used not in the conventional sense of a document of agreement with signatories, but as an act of agreement. This is, my lord, the heart and soul of section 7. Whether contractual, not contractual, if it gives rise to a defined legal relationship and there is a reflection of some act by even non-signatory agreeing to something by each and every mode, whether contractual or not, and may be between more parties, if all of them constitute a legal relationship in a transaction. This is how, my lord, the letter of section 7 will be infused with spirit and blood by your lordships by interpretation.
No, Mr. Mehta,
My lords.
see, the contract, the correspondence between A and B, and what they decide is, it is the C who will supply. But C is not a signatory, the example that you have taken. Now, unless there is a conduct in furtherance of the contract between A and B by C, you can't rope in C. There has to be a conduct.
Your lordships are right.
And the conduct is in furtherance of the contract between A and B, although C is not a signatory. So therefore, just the correspondence between A and B will not dragging C under the group of.
I bow down, your lordships are right. My lord, the example which I would wish to give to buttress my argument would be this. What is essential is something should emerge to be a defined legal relationship. Number one. Number two, it need not be a document signed by two parties as an agreement. It can be exchange of letters. Now, in the same example which my lords were pleased to give, not suppose there is a correspondence between A, B, C, A to C, C to B, B to A. And if it can be found out that because of this correspondence, though the arbitration clause is only between A and B, but C has also participated, he was a part of the negotiation process, he also given certain assurances, etc. Then C cannot say that I am not a signatory to the contract between A and B, and therefore I cannot be a part.
Therefore, in this example, really speaking, there's a predefined relationship, pre-existing relationship between A and C when A agreed to
Or B and C for that matter.
A, B, and C, Mr. You are A or you are C. Mr. Khambata is A and Mr. Diwan is B.
Correct.
So when A agreed to supply goods to B, and there is obviously in your example, there is exchange of correspondence, there is an exchange of emails, there is an exchange of communication between C and A and B, and by which C also is intrinsically a part of either the negotiations or the performance or the execution of the contract. These cases may not be that difficult. Question will arise where C has completely stood separately and away from the contract.
Bystander.
He's a bystander. But there is a pre-existing relationship between A and C, which is what you, I'll just go back to your, the way you have formulated it at page 7. A, an agreement, arbitration agreement as understood under the Act is not a conventional agreement only. Fair enough. An arbitration agreement can take place whenever certain disputes arise among entities when such entities have a defined legal relationship.
That exists must.
That is your relationship with C's relationship with A. Then C.
No, with the dispute.
With the dispute.
No, exists not with the parties. Existence of a defined legal relationship was a dispute.
With the dispute.
Was the contract, I would say, was the contract.
We'll add in B then. Have a defined legal relationship with the dispute or the contract.
Or contract. I may not be a signatory to the contract, but I have from the exchange of correspondence by some action. For example, my lord.
So long as we say with the contract, I think then it becomes a little more structured.
Yes.
Once we add with the contract.
Correct. My lord, for example, there is a tender floated by Mr. Diwan, and my learned friend Mr. Khambata is participating, where there is a requirement that some company having more than 500 crores turnover will stand as a guarantor so that he can supply the goods to him. I am that company. I stand as a guarantor, and there is an exchange of correspondence. Then it will be, my lord, a fact-specific determination. But I cannot say that because I am not a signatory to your contract, I am out of it. If there is a defined legal relationship emerging from our actions, because therefore the legislature says contractual or not, there can be a defined relationship without entering into a formal contract.
So how does this relationship come in? By your agreeing to be the guarantor in the contract between A and B. So therefore you have entered into, or you have acted in a manner which has furthered the contract. So you can't be saying that I am a bystander there. In that.
Therefore, you can't be saying in that case that, look, I'm not a formal party to the arbitration agreement, which was a contract between A and B, which contains the arbitration agreement.
For example, there is a...
Ultimately, Mr. Mehta, therefore, it boils down to how you will interpret that particular fact situation.
Exactly. It will
So really, you should not be laying down
fact-specific determination.
You should not be laying down extremely rigid or tightly controlled.
Cannot be and should not be. That's my respectful support.
Then it will be very dangerous.
Yes. Well, that cannot be, and that's what I have said, that it will have to be a fact-specific determination. Suppose a Chinese company has a local Indian company as its subsidiary and is entering into contract with local Indian other companies or other individuals, and say and the Chinese company agree that yes, we are behind it, we are a financially sound company, you can enter into this relationship and there is an exchange of correspondence, which gives rise to a defined legal relationship. Its relationship is not that of a mortgage, that of a guarantor. The legislature doesn't use a particular kind of defined legal relationship. Any defined legal relationship,
Whether contractual or not.
contractual or not. So that's my respectful submission. Lord, para 18, Lord, your lordships need not read, I'll just orally point out. Your lordships were shown
What
that
would be examples of non-contractual legal relationships?
Lord, non-contractual, I have given Lord, some of the examples. There are several theories, Lord, which have emerged in other jurisdictions. Lord, for example, back-to-back contracts. Lord, they have a contract. They have to have a contract. I am not a signatory. I am not bound by any defined legal relationship. But I have a back-to-back contract with you. And the facts suggest that I'll supply to him, which he will in turn supply to. So technically, there is no contractual relationship so far as I am concerned. As far as Law Commission's report is concerned, your lordships have seen. I'm sorry, the report. Lord, Law Commission.
B and A materializes and B ultimately supplies the goods to C. Transaction, C is not at all aware what is going on between. One fine day, problems crop up. What do you intend to do? B says, I have taken up the issue with A. I have nothing, how am I concerned? Can C drag A into the
Cannot. And the reason is simple. There is no defined legal relationship which came into existence.
So
But
therefore, one or two instances, Mr. Kambata may also assist us. What could be a good example of a non-contractual legal relation?
Therefore, my lord, in this very example, my lord, I'll point out. C wants some goods, my lord, and he believes that B will be able to supply it. Now, there is an exchange of correspondence between them that I want this description of goods.
You may develop it a little that in this confusion, there may be some correspondence between A and C at a
And
later point.
exactly, I'm coming to that. I'm coming.
Perhaps C may be able to drag A.
Correct. Exactly, that's what, my lord, I'm. In the example which your lordships have given, there does not come into existence any defined legal relationship between C and A. So this doctrine cannot apply. But when C approaches B, that I want this particular description of goods, and only A will be able to supply because this category of goods or description of goods only he manufactures. You are the retailer or a wholesaler. B approaches A, and there is an exchange of correspondence between three of them. A says, yes, I am agreeable if you enter into a contract as per this schedule of distribution or this schedule of supply. I will be able to supply every month 300 units, and I assure C that I'll supply it to B. Whatever is your financial arrangement, you have your financial arrangement. I can only say that I'll be able to supply. Now, a defined legal relationship comes into existence. He is not just a bystander, as my Lord Justice Roy, my Lord, very rightly, my Lord, coins the word. He is a party to the negotiation. The very fulcrum of the contract is based on his agreement. He is not a signatory in the contract between B and C. But if a dispute arises because of his failure of supply, then he can't run away from the responsibility only on the ground that he is not a signatory to B and C. That's, my lord, the contours of the document.
So again, a fact situation.
It will be very dangerous to set out all the circumstances.
It should not be.
In fact,
Should not.
The constitution bench should not even attempt to do
No,
that,
no, no.
because we must respect the wisdom of the courts concerned.
Fact situation might differ.
Particularly in commercial matters, you must leave a certain degree of flexibility for courts to,
There are two or three things, my lord, why in my
modulate their decisions based on the situation, unless there's something really positively erroneous in the doctrine. Because ultimately you have to evolve the doctrine based on, the facts as they will emerge before succeeding benches.
No, therefore, no, my ultimate, the fulcrum of my argument is that your lordships would decide whether this doctrine is excluded from Indian law, and if not, whether the doctrine is applicable, and the fact situation in each case to be decided, my lord, either at the stage of section 8 or at the stage of section 11 or maybe at the stage of section 16. Somebody may raise a dispute, my lord. Section 11 comes when there is no agreement between the parties and we have to approach the Honorable Chief Justice or his lordship's designate. But suppose there is a dispute between the two of us, we jointly go before an arbitral tribunal, joining C also. He can raise all these issues.
Actually, Mr. Solicitor, the last few words of section 7.1, which may have arisen or which may arise between them in respect of a defined legal relationship, without contractual or not. These words define what is the origin of the dispute or what is the source of the dispute. The dispute, there has to be an arbitration agreement. An arbitration agreement is an agreement to submit disputes which have already arisen or which may arise in future. There's no dispute today, or which may arise in future.
But existence of relationship.
But which may arise between them and in respect of a defined legal relationship, whether contractual or not. So these words, in respect of a defined legal relationship, whether contractual or not, refer to the source
of dispute or
source
the
of
contract.
The dispute must arise either through a contract or it may arise through a legal relationship other than a contract.
Yeah.
So, for instance, I'll give you an example. Just, I mean, it may sound a little, I just concocted it here. Suppose a builder has a large tract of land. He carves out plots and assigns plot A to A, plot B to B, plot C to C, plot D to D, plot E to E. Now, there is no relationship between, there's no contractual relationship between A, B, C, D, and E,
Correct.
right?
Complete
So the
bystanders,
contractual relationship
strangers.
is only between A and the builder and A, the builder and B, the builder and C. But suppose in future a dispute arises between the individual purchasers over the sharing of common amenities or the sharing of a common source of water or a green area, so on and so forth. There might be then an arbitration agreement which says that any dispute between them, A, B, C, D, and E, will be arbitrable. Because then there is no contractual relationship between A, B, C, D, and E unless they've entered into a cooperative society or a condominium. But by virtue of the fact that they are neighbors, there is an element of a legal relationship, what you shall do and what you will not do to a neighbor. Okay, so therefore that is a sort of a dispute which may be an arbitrable dispute in the future. There is no contractual.
But
The
in this,
definition, section 7 doesn't talk about arbitration contract.
I was,
So it is talking about arbitration agreement. Agreement is defined under the Contract Act, where there is an offer and an acceptance. Contract is defined as an agreement which is enforceable in law. So there are two legal relationships. One is a legal relationship of a contract, another one is a legal relationship of an agreement. Contract Act contemplates entire regime with respect to how to enforce a contract and also how to enforce an agreement. So far as agreements are concerned, 68 onwards talk about certain relationships resembling those created by contracts. So therefore, those aspects which have not emerged into contracts can also be subject matter of an arbitration. So therefore, it's a holistic.
yes,
An arbitration can be with respect to enforcement of contracts. It can be with respect to, that is more or less similar to specific performances.
correct.
So which is also, though it's not a contract, nevertheless, it has come within the fold of an arbitration agreement. That is how it takes within
Yes,
the three
now,
buckets.
apropos,
To take it little further, what Arbitration Act is talking about when it's speaking under section 7 of arbitration agreement, there are three inviolables there. First and foremostly, written agreement is necessary, not contract, written agreement. Second is parties are necessary, but these two are not frozen. 4B gives meaning to it, saying parties as well as legal relationship is inferable from what is defined as the record of agreement. So
Not
what we have,
agreement
therefore,
in
what
writing,
the
but
court
record.
does- What the court does is, court has in every case look into the existence of parties. That's also inferable from the record of agreement. Court will also have to see the legal relationship, which is also inferable from the record of agreement. So we will have actually a written agreement, not in terms specified as A and
act
B.
of agreeing.
A and B, but whether A, B, C, or D are inferable from the record of the agreement. And similarly, the relationship is also inferable from the record of agreement. So, really speaking, coming to the question, what is
What
the
are we
Constitution
deciding?
bench supposed to do? It's already there. Why this
But
reference?
the argument was
We can
that
perhaps
the
discharge the
doctrine,
reference.
the argument was that there is an exclusion of the doctrine.
There's no
There
specific
is the
subject to
judgment
hearing
which
Mr.
is
Rai.
staring in our face.
Lord, another thing. Lord,
There's no
apropos, my
specific
lord,
exclusion, as you rightly said.
Lord, apropos, my lord Justice, my lord.
I'll give you another example of a legal relationship which was not contractual, which can be subjected to arbitration. Suppose there are 5 brothers and sisters. They have a common property. They want a partition of the property. they want their shares to be identified, or the shares are given in law, but they want a division by metes and bounds. There's so many arbitrations which take place. There's no contractual relationship between the members of a family. If they are partners, there's a contractual relationship.
So, Lord,
Because then there's a partnership
Your
agreement.
Lordships are.
But if there is a non-partnership dispute between, say, members of a family, you can submit that dispute to arbitration. What is excluded, of course, is just that, just as Ravindran said, where it's, in rem, then you can't.
That's correct.
So you can't, it's a will.
Indo.
So the will operates in rem. Once will is probated, probate can't be referred to arbitration.
So it's in rem.
Or that's right. Or something which is determinative of legal status, like the paternity of a child. That you can't refer to arbitration. As just Ravindran carved out, admiralty.
1, 2, 3. My Lord, 3 areas are covered. Lord, now, apropos, my Lord, your Lordship, my Lord, the
Therefore, when you agree to an arbitration, the dispute may not emanate from a contract at all. It may emanate entirely from an area other than a contract. That's right.
Look, kindly, my Lord, taste your Lordship's example, my Lord, again for 7-1. Again for 7-1, my Lord. Kindly, I'm sorry. My Lord, Justice Narasimha.
No, nothing, sorry. You go
No,
ahead.
I'll do.
Yes, Mr. Mehta. So,
Yes, Lord, taking your Lordship's example, just my Lord, then I'll move on to the other point. Lord, kindly see 7-1 in a scenario which, my Lord, the Chief Justice of India. Matter of fact, discovery, chair, and etc. Your Lordships have examined the fact-specific situations. In fact, it never required a reference. I'll assist your Lordship. Kindly come to 7-1 again, my Lord, in the context of your Lordship's my Lord, illustration that a builder having a separate agreement contract with A, with separate with B, separate with C, and some dispute between A, B, C, D. Now, please see, it is in this part, arbitration agreement means an agreement by the parties. So, builder can't be roped in unless there is something to suggest that he also has acquired certain responsibilities.
way that dispute, the way the